Good morning. The Easementary right always a subject of dispute between the parties, particularly in villages and hilly areas where the properties owned by the villagers could not be used properly without having access of enjoyment to others' property, neighboring properties. That is called a dominant heritage and servient heritage. The person who dominate others' property is called the dominant heritage. The the the, the person who is legally supposed to allow the neighbor to have access through his property is called the servient heritage property. The problem is I am going to share this case law because poor drafting, poor legal advice. AIR 2024, Supreme Court 1947. AIR 2024, Supreme Court 1947. The person who sought for easementary right under section 15 and under section 13 and 4. In the draft, they failed to specifically claim that the plaintiff was enjoying the egress and ingress in the rasta. Rasta means road. For over 20 years, because to invoke section 15 of Easementary Act 1882, it is necessary that you should plead that you are enjoying the property of others for more than 20 years. That was not pleaded. Therefore, however, the lower court decreed the suit, the appellate court dismissed, set aside the degree. Second appeal was also against plaintiff and this simple formula. And when it go to Supreme Court, AIR 2024, Supreme Court 1947, Manisha Mahendra Gala and others versus Shalini Bhagwan Avat Ramani. Here, what had happened, after filing the suit by this Galan company, the defendant also filed a suit to declare and restrain the Manisha Magendra Gala and others not to interfere with the exclusive right of using their rasta. That was initially dismissed by the lower court. Appellate court set aside that and decreed in favor of the Avatar Ramani. And then second appeal. So the Supreme Court, after confirming the appellate court, second appeal court, high court, as well as and this court, held that since not only pleaded specifically, but they have also, there was no evidence. They simply says mechanically that they are using for last for many years. That is not sufficient. That was the verdict. And if you want to understand the entirety of the judgment, you must go through the other ratio also. That what was the other ratio was that the person who sold the property to the plaintiff did not mention anything about using this rasta permission, but the subsequent vendor sold the property, same property, mentioning that he is having right over the rasta. So that was rejected. Then another, they say there is already the another way alternative way for the plaintiff. These things were discussed. So, go through the paragraph 19, wherein Section 4 of the Easement Act was discussed and clearly stated. Then Section 15 also at paragraph 22. So you must go through all these things so that if you are practicing in village and there is possibility, and nowadays this easementary right would also prevail over apartment systems. I did not notice any such cases obstructing the usage of common area by the plot owners. Let us wait. Therefore, you constant with this judgment on your book and library. It may help you. Best wishes.